My father called me the night after Grandma Helen's funeral and said there was nothing in the estate care for me. He said she had loved me. He said she had always loved me. He said the money had simply gone to cover her final years. The memory care facility, the medications, the private nursing aides she had needed at the end. He said it the way people say things when they have practiced the words enough, that the delivery sounds natural. I said okay. I thanked him for calling. I hung up. Then I sat at my kitchen table in Louisville, Kentucky, and I thought about the last real conversation I had with my grandmother 8 months before she died, when she was still clear enough to be herself. She had held my hand and told me she had taken care of me. She said it twice. She looked directly at me both times, the way she looked at people when she needed them to understand something. Not a figure of speech. A statement. She had taken care of me. My parents said there was nothing left. One of those things was true. My name is Diane Cho. I am 39 years old and I have worked in forensic accounting and estate audit for 12 years. My practice is almost entirely probate disputes, cases where someone believes an estate was mismanaged, misreported, or quietly redirected before the rightful heirs saw a single document. I was raised in Louisville in a household that ran on my grandmother's presence as much as my parents'. My mother worked 2 jobs through most of my childhood, a day shift at a medical office and evenings at a department store through my elementary years. My father was a regional sales manager, home on weekends and gone the rest. Grandma Helen was what made the week work. She picked me up from school every day until I was old enough to take the bus. She made dinner on Tuesday and Thursday nights, and sometimes Friday too. She sat at the kitchen table and helped with homework she didn't fully understand but refused to dismiss, asking questions until I could explain what I was doing in my own words. She was at every school play, seated near the front. She drove 40 minutes to my county spelling bee when I was 10. She came to my high school graduation with a card that had $50 in it and a note in her handwriting that said she was prouder of me than she had words for. Rude. She drove to my college graduation too at 76 with a thermos of coffee because she didn't trust Rest Stop coffee. She was the most consistent person in my life for the first 22 years of it, and I loved her without complication. She had saved carefully her entire adult life. My grandfather Harold died when I was 12 suddenly of a heart attack. He left her the house, a 3-bedroom brick ranch she had lived in for 31 years, a paid-off mortgage, and a modest investment account she managed quietly for the 25 years after his death. She did not make large moves with it. She left it in low-cost funds and reinvested dividends, and never touched the principal. She was not wealthy, she was the kind of careful that compounds over time when nobody touches it. When she was diagnosed with early-stage dementia 4 years before her death, my parents stepped in. They petitioned the court to be named co-trustees of her living trust she had originally executed 12 years earlier, when she was 71 and fully competent. They managed her accounts, paid her bills, coordinated with the memory care facility, and made every financial decision on her behalf from that point forward. My father called this sacrifice. It was, in some real ways. Caring for an aging parent is hard and unglamorous and relentless, and I was not there to share it. I was in Louisville. They were in Cincinnati. I visited when I could. I called every week. But the daily weight of it fell on them, and I have never pretended otherwise. What I have a problem with is what they did with the money. The estate opened 6 weeks after the funeral. My parents used a local attorney named Robert Fisk. Fisk mailed me a courtesy notice as a named party in the original trust document. Grandma Helen had included me by name when the trust was first drawn up, leaving me a 1/3 share alongside smaller bequests to her church and a cousin. That notice was the first piece of estate information I had received since my father's phone call. I had not been consulted during the administration. I had not been shown statements or billing records or facility invoices. I had been called once and told nothing remained, and that had been the extent of my involvement. I called Fisk's office and asked for the current trust document. His assistant told me the trust had been restated, fully rewritten, 3 years earlier, during my grandmother's memory care residency. The restated version, she said, did not include my name. I asked when the restatement had been executed. She gave me a date. I wrote it down and sat with it for a moment. My grandmother had been in memory care for 14 months when that document was signed. I asked who had prepared the restatement. Robert Fisk's office. The same attorney who was now administering the estate had prepared the document that removed me from it while my grandmother was living in a memory care facility. I asked for copies of the restated trust and the estate inventory, or she said she would mail them. The documents arrived 4 days later. I spread them across my kitchen table with a legal pad, a highlighter, and the same approach I use with every financial document I am paid to examine. Every line read, nothing assumed, nothing skimmed. The first thing I looked for was the date the restatement was executed. I found it at the top of the first page. I wrote the date on my legal pad and drew a box around it. Then I counted backward. How many months had my grandmother been in memory care by that date? 14 months. I wrote that next to the date. 2 numbers side by side, not yet connected to anything else. But I had been doing this work long enough to know that the connection was coming. The restated trust named my parents as the sole beneficiaries. My bequest was gone. The church bequest was gone. The cousin's bequest was gone. 12 years of my grandmother's planning, removed in a single restatement with my parents as the only names remaining. The estate inventory was 2 pages. The house, sold 18 months before my grandmother's death. Sale price, $218,000. Net of commissions and closing costs, listed under the inventory description as proceeds applied to memory care expenses, the investment account, closed 14 months before her death. Balance at closure $94,000, listed as proceeds applied to memory care expenses, a checking account, $4,100, remaining at death, total estate value, $4,100. My grandmother had owned a paid-off house and a $94,000 investment account. She had died with $400 in her checking account. My parents had described $312,000 in assets as consumed by the cost of her care. I pulled a legal pad and started with the one number I could verify independently, what the memory care facility had actually charged. The facility's patient accounts office released a billing summary after I submitted documentation of our relationship and a written request. It took 11 days and 2 follow-up calls. The summary was 4 pages. The facility charged $6, $200 per month for my grandmother's level of care. She had been a resident for 41 months. Gross facility cost, $254,200. I requested the insurance explanation of benefits from her Medicare supplement insurer. 3 weeks, 2 formal letters, and a notarized affidavit of relationship. The EOBs arrived in a thick envelope, 32 pages of claims and payments covering her full residency. Medicare and her supplement had covered $138,000 of the facility costs. Her actual out-of-pocket responsibility to the facility, $116,200. That was the real number, not $312,000, $116,200, fully documented, verified against both the billing records and the insurance payments. She had entered memory care with $312,000 in assets. Her legitimate care costs totaled $116,200. The gap, $195,800, $195,800 unaccounted for in the estate inventory. I sat with those 2 numbers for a long time, $116,200 and $312,000. The gap between them was not a rounding error or an accounting ambiguity. It was $195,800. That is not a number that gets misplaced. It does not fall through the cracks of an honest administration. It goes somewhere deliberately. I wrote the gap on my legal pad, circled it, and started a list of questions underneath it. Where did the house proceeds go after they were deposited? Where did the investment account proceeds go? Were they even deposited to her account? What does 4 years of trustee activity actually look like in the bank records? What were the transfers by date and amount to any account other than the memory care facility? I could not answer those questions from the estate inventory alone. The inventory showed beginning and ending balances and a description. It did not show the movement in between. The movement in between was the entire case. I called Patricia Song the next morning. Patricia is an estate litigation attorney in Louisville, who I had worked with on 3 previous cases. She is 53 years old, direct, and has no patience for the kind of procedural delay that opposing counsel uses to wear clients down. When I walked her through my numbers, she listened without interrupting. When I finished, she said, "Lynn, the restatement date, how certain are you about what her cognitive status was at that point?" I said I need her medical records to confirm it. But 14 months into a dementia diagnosis at her age, my professional experience says it is very unlikely she had full legal capacity. Patricia filed the estate dispute with the probate court and simultaneously requested my grandmother's medical records from the facility, obtainable under the estate proceeding, and issued a formal discovery request for 5 years of bank records for my grandmother's checking account, the investment account records from the point of closure, the house sale closing documents, and all financial records my parents had held in their capacity as co-trustees. My parents hired Douglas Webb, a Cincinnati attorney who handled estate litigation and who responded to discovery with a series of objections. Patricia described to me as standard delay tactics, each one technically valid enough to require a response, none of them substantively challenging the core request, all of them designed to add weeks to the process. Patricia had seen it before. She filed a motion to compel within 10 days of each objection, for each time attaching our supporting documentation, and the $195,800 gap figure prominently in the opening paragraph, she told me. Judges in probate court see this pattern regularly. When the gap is this large and the documentation is this specific, they don't like delay. The probate court judge, Honorable Carla Fields, reviewed our motion to compel and granted the full discovery request. In her order, she noted that the gap between stated care costs and documented care costs raised questions of sufficient specificity to warrant full account transparency. Webb had 30 days to produce. He produced on day 29. First, the package arrived at Patricia's office at 4:47 in the afternoon, a banker's box of printed statements and a thumb drive with the scanned originals. Patricia called me and I drove to her office that evening, Bristol. We opened the box together and I started with the checking account records. It took me 6 days to go through everything. I worked at Patricia's conference table with 2 monitors, the printed statements spread in chronological order, and a spreadsheet open on one screen and the source documents on the other. I cross-referenced every number before entering it. Nothing in my spreadsheet was estimated, every figure tied to a document in the box. The medical records arrived separately, from the facility within the discovery timeline. I went to those first. My grandmother's admission assessment documented moderate early-stage dementia at the time of her intake. Her quarterly cognitive evaluations charted a consistent decline over the following 3 years. The evaluation closest to the trust restatement date, conducted 11 days before the document was signed, showed a score in the range the attending physician described, in writing, as consistent with moderate to severe dementia. The physician's note stated, "Patient lacks capacity for complex financial and legal decision-making. All such decisions require guardian or trustee oversight." Robert Fisk had prepared a legal document for a woman who, according to her own physician's records 11 days prior, lacked the capacity to execute it. I made a note in the file and moved to the bank records. The checking account records were 140 pages covering 5 years. I went through them in 2 sittings, each about 4 hours. First, the account had received the house sale proceeds as a single deposit, $218,000 net, arriving 18 months before my grandmother's death. Over the 14 months that followed, the account was drawn down in 2 ways. First, payments to the memory care facility. I cross-referenced each facility payment against the billing summary. The facility payments totaled $78,400 across the full period, consistent with the out-of-pocket cost after insurance, properly documented, entirely legitimate. Second, 43 transfers to my parents' joint checking account, 43 transfers over 14 months, amounts ranging from $500 to $8,000, no regular pattern, no consistent interval, no amounts that corresponded to any invoice or recurring expense in the records, together, $127,400. The transfers were the part I kept coming back to because the pattern told a story by itself. A trustee reimbursing legitimate expenses from a beneficiary's account would typically do so in regular intervals, with consistent documentation, monthly expense reports, logged against invoices. What the checking account showed was different. The transfers came whenever they came, 2 in 1 week, nothing for 6 weeks, a large one followed by 4 small ones. No pattern that corresponded to billing cycles, monthly cost, or any rhythm that caregiving expenses would produce. That irregularity is a signature. In 12 years of estate examination, I had seen it before. It is the transfer pattern of someone who dips into an account when they need money, not when an expense requires it. It is the pattern of someone who has decided the account is available to them, without formally deciding anything at all, just reaching in, transferring and continuing, 43 times. I built a separate column in my spreadsheet for each transfer, date, amount, running total. By the time I finished the checking account records, the column had 43 rows and the total was $127,400. First, the investment account records were simpler and worse. When the account was closed, the $94,000 liquidation was not deposited to my grandmother's checking account. It was wired directly to a joint account in my parents' names. It never passed through her accounts at all. It went straight to theirs. The estate inventory had described both the house proceeds and the investment account as applied to memory care costs. First, the house proceeds had at least touched her account first, from which the facility had been paid. The investment account had bypassed her entirely. Of the $312,000 in total assets, $78,400 had gone to the facility. Everything else, $233,600, had moved to my parents. Then I looked at my parents' account records, which Douglas Webb had been required to produce under the discovery order covering trustee activity. The $127,400 transferred from my grandmother's checking account over 14 months had been spent as follows: $34,000 in payments to a residential contractor, Bruton. I pulled the permit records for my parents' neighborhood and confirmed a kitchen renovation permit was issued in that period. The permit described a full kitchen gut and remodel, $28,000 to an auto dealership, a vehicle purchase, $19,000 in credit card payments, made to a card that showed 4 large travel charges over 2 years, airfare, international hotels, resort charges, 4 trips, the remaining $46,400 absorbed into general household spending, groceries, utilities, restaurants, the ordinary costs of a life lived on someone else's money. The $94,000 from the investment account had been handled differently. Wrong. $31,000 went to a brokerage account in my mother's name only. Opened the same month the investment liquidation was processed. $28,000 more went to the kitchen renovation. 4. The remaining $35,000 had been spent down over 18 months from their joint account. I did not need to do any more arithmetic. The picture was complete. My grandmother's $312,000 had gone to a kitchen remodel, a new car, 4 vacations, a private brokerage account in my mother's name, and 14 months of general household expenses. The facility had been paid $78,400 from the house proceeds. Everything else was gone. I called Patricia and told her what the records showed. She said, "I'm filing a motion for an emergency account freeze today." Judge Fields granted the freeze within 48 hours. Frozen. My parents' joint accounts were frozen pending the outcome of the dispute. My mother called me the night the freeze went through. Phrase. Her voice had the quality of someone who had prepared a speech and then abandoned it somewhere between dialing and the first ring. She said, "You don't understand how hard those 4 years were." I said, "Tell me." She said, "Every call from the facility, every decline, every time she didn't know who we were. You weren't there for any of it. You sent flowers on her birthday and called on Sundays and acted like that was the same as being there." I said, wrote, "You're right that I wasn't there the way you were. That was a failure on my part, and I've thought about it a great deal. But there is a process for compensating trustees for caregiving time. It requires documentation. It requires court approval or beneficiary consent. It does not involve wiring $94,000 directly from an incapacitated woman's investment account into your joint account the month it's liquidated," she said. "We were her children." I said, "She put my name in her trust. She held my hand 8 months before she died and told me she had taken care of me, and then I received a call telling me nothing was left, and now I have the bank records." She did not respond. I said, "I don't want to do this the hard way, Mom, but the records are what they are." She said, "Your father will call you." She hung up. My father called 2 days later, measured and careful in the way of someone who had spoken to an attorney before picking up the phone. His voice had the quality of a prepared statement, organized, flat, stripped of anything that could be used against him. He said, "Bree, we'd like to resolve this without things going further." I said, "I'm open to that." He said, "We're willing to acknowledge that the trust accounting wasn't as formalized as it could have been. We were managing a very difficult situation under a lot of pressure, and some of the bookkeeping suffered." I said, "Dad." He paused. I said, "I have 43 transfers totaling $127,400 from Grandma's checking account to yours. with no corresponding invoices or trustee records. I have a $94,000 investment liquidation wired directly to your joint account. It never touched hers. I have her cognitive evaluation from 11 days before the trust restatement showing the attending physician documented in writing that she lacked capacity for complex financial and legal decisions. I have Robert Fisk's billing records showing his office prepared that restatement. And I have the spending on the other side, the kitchen renovation, the car, the 4 international trips, all paid from funds the estate inventory described as applied to her care. A long silence, he said, "We provided her with years of care." I said, "You did, and if you had documented a trustee fee and had it approved, we could have discussed what was reasonable. But that's not what happened. What happened is that you restated her trust while she had dementia, removed me and her church, and took $230,000 from her accounts, free, and then you called me after her funeral and told me there was nothing left." He did not respond immediately. When he spoke, his voice had shifted slightly, still controlled, but with something underneath it that sounded like the effort of maintaining control. He said, "What do you want?" I said, "What she intended me to have. Reinstatement of the original trust terms, my 1/3 share after legitimate care costs, and a referral of Fisk to the state bar." He said, "We need to talk to Douglas." I said, "The account freeze stays until we have a signed agreement." Brown. The mediation was held on a Wednesday morning in February at a conference room in the probate court building in Cincinnati. Patricia and I drove up the night before and stayed at a hotel near the courthouse. We spent 2 hours that evening going through the presentation order, which documents first, which numbers to lead with, when to place the physician's note on the table. Leonard Marsh, the mediator, was a retired family court judge who had been mediating estate disputes for 15 years. He had the unhurried quality of someone who knew the shape of a situation before anyone finished explaining it. When Patricia handed him the financial summary, he read the first 2 pages standing up before he sat down, which told me he had already understood the structure of what we were presenting. My parents sat across the table, and I looked at them for the first time in person since my grandmother's funeral. My mother had aged in the year since, or I was seeing her differently now, with the records between us. My father kept his eyes on the mediator and the documents, not on me. He had the composed stillness of a man who had decided the best posture was to show no posture at all. My parents arrived with Douglas Webb. My mother was in a gray blazer. My father wore the same expression he wore at my grandmother's funeral, carefully composed, slightly above the emotion in the room. They sat across from us and did not look at me directly. Patricia placed the financial summary on the table. One document, 8 pages, organized in the same order as the spreadsheet. Every transfer, every amount, every source account and destination account, the facility billing totals, the insurance reimbursements, the gap, she said. The estate inventory described $312,000 in assets, as applied to memory care costs. The actual documented cost of Mrs. Whitmore's memory care, after insurance, was $162,200. The remaining $195, $800 moved through trustee-controlled transfers to the respondent's personal accounts and was spent on personal expenses including a kitchen renovation, a vehicle purchase, and 4 international trips. Douglas said, "The trustee transfers reasonable compensation for 4 years of caregiving." Patricia placed the physician's note on the table. She said, 11 days before the trust restatement was executed, Mrs. Whitmore's attending physician documented that she lacked capacity for complex financial and legal decision-making. The restatement was prepared by the same attorney, now administering the estate. The restatement removed the petitioner and 2 other beneficiaries named in the original trust. The transfers were not documented as trustee compensation, were not court-approved, and were not disclosed as compensation in any estate filing. She paused. "These are not accounting discrepancies. These are misappropriations of trust assets from a woman who could no longer protect herself, compounded by a trust restatement she lacked the capacity to execute." Douglas wrote something on his legal pad. My mother was looking at the physician's note. My father was looking at the table. Leonard Marsh said, "I'd like a recess before we move to settlement parameters." They were gone 45 minutes. When Douglas Webb came back in, he sat down and said, "My clients are prepared to settle on terms that acknowledge the original trust terms and address the asset distribution." The negotiation took 3 hours. Douglas Webb was a skilled negotiator. He knew when to push and when to concede, and he moved with the practiced efficiency of someone who had settled dozens of these cases and understood which hills were worth defending. He pushed hardest on the trustee compensation argument, for he argued that my parents had spent 4 years managing a complex caregiving situation, that the reasonable value of that management exceeded the documented transfers, and that the court should recognize a retroactive trustee fee before calculating the distributable estate. Patricia said, "A trustee fee requires contemporaneous documentation, reasonable rate, and either court approval or beneficiary consent. None of those conditions were met. These transfers were made without any documentation as compensation and were spent on a kitchen renovation and international travel. The court will not retroactively characterize personal spending as professional compensation." Webb shifted to the trust restatement. He argued that even with the cognitive evaluation, free, there were periods of clarity that could support capacity arguments, and that the restatement should be presumed valid absent a formal incapacity adjudication at the exact moment of signing. Patricia placed the physician's note back on the table. She said 11 days, and the physician used the phrase lacked capacity in writing. "We are prepared to call the attending physician to testify." Douglas wrote something on his pad and did not push the restatement argument further. On the trust restatement, my parents agreed not to contest a petition to void the restated trust on incapacity grounds. The original trust terms were reinstated by stipulation. On the asset calculation, the legitimate memory care costs, $116, $200 in documented out-of-pocket facility expenses, were deducted from the total asset base of $312,000. The remaining distributable amount was $195,800. Under the original trust terms, I was entitled to 1/3. 65th MZ267's the church bequest, also removed in the restatement, was reinstated at the original designated amount of $15,000. My parents retained the remainder of the estate, approximately $115,500, after the deductions for my distribution, the church bequest, and legal costs. They were also required to pay their own legal costs, which Douglas Webb's fees would have made significant. Patricia had pushed for a larger recovery, the full $195,800, arguing that the trustee misappropriation should be treated as a complete offset against my parents' share. Douglas Webb resisted and Leonard Marsh split the difference in the framework. I accepted. I was not there to take everything, for I was there to get what my grandmother had intended me to have. The payment arrived 90 days after the mediation, free, transferred to the estate account, and disbursed by a neutral third-party administrator Patricia had insisted on as a condition of the settlement. When it cleared, I was at my desk in Louisville. I noted the receipt in the file, updated the spreadsheet, and closed the case. Robert Fisk received a formal referral to the Kentucky Bar Association. The referral was supported by the cognitive evaluation, the timeline, the restatement document, and a letter from Patricia detailing the ethical obligations of an attorney, preparing a legal document for a client with documented incapacity. The bar reviewed the case and issued a formal reprimand. Fisk was required to complete additional training in elder law ethics. He did not lose his license, Bruce. Whether that is sufficient consequence for drafting a document that removed 3 beneficiaries from a dying woman's estate, while she lacked capacity to understand what she was signing, is a question I have thought about more than I expected to. An attorney has an obligation to assess client capacity before executing a significant legal document. A cognitive evaluation 11 days prior showing documented incapacity should have ended the engagement, not proceeded to signature. Robert Fisk either did not know about the evaluation, did not ask, or asked and proceeded anyway. None of those options reflects well on him. The reprimand is on his public record. Anyone who searches his name through the Kentucky bar will find it. That is not nothing. It is also not enough, by any measure I am comfortable with. But it is the outcome that happened, and I have put it in the file alongside everything else and closed the drawer. My parents and I have not spoken since the mediation. My mother sent a Christmas card, a printed one, with a generic winter scene and her signature and nothing handwritten inside. I looked at it for 2 days and then filed it, where I file things that require no further action. My father has not contacted me. I do not expect him to. He is a man who processes difficult outcomes by moving past them rather than through them, and I think he has decided that the mediation was an outcome to be moved past. Free. I do not know whether he believes he did something wrong. I genuinely do not know. There is no version of reconciliation I can see clearly from here. Fool. They are my parents, and I loved them, and they took money that my grandmother tried to leave me from a woman who could no long protect herself. And they did it carefully enough that they believed it would never be found. Those things coexist, and I do not know what to do with the coexistence except to sit with it honestly and not pretend it is simpler than it is. My grandmother would not have wanted this outcome for the family. I know that. She was a woman who believed in keeping things together, in not letting money sever what love had built. She gave my parents 4 years of gratitude and trust, and they used that trust in a way she could not have anticipated or stopped. First, she also put my name in a trust document 12 years before she died, with a 1/3 share clearly stated, in language no attorney could misread. That was not an accident. She thought about me when she sat down with that attorney, at 71, and she made a deliberate decision about what she wanted me to have. That decision survived a restatement. It survived an estate inventory that described $312,000 as consumed by care costs. It survived a phone call in which my father told me there was nothing left. It survived because she had the foresight to write it down, and because I had the training to find it. My grandmother's money sits in an investment account I opened specifically for it, and manage with the same approach she used. Low-cost funds, reinvested dividends, principal untouched. I have not spent any of it. I am not sure I will for a long time. It does not feel like money to be spent. It feels like something to be tended, to grow the way she intended it to grow, toward a use that honors what she meant. She saved that money over decades, adding to it slowly after my grandfather died, reinvesting quietly, watching it compound. She had a plan for it. She told me so 8 months before she died, holding my hand and looking directly at me. She had taken care of me. She had. The original trust said so. The records confirmed it. And no restatement, however carefully timed, however cleanly drafted, however confident in its own concealment, could make the bank records say something other than what they said. Versi. The only question was whether anyone would read the records carefully enough. I have spent 12 years reading records like these. I read them for other people's families. Me. I read them for strangers who called me in grief and confusion and sat across from me while I walked them through spreadsheets showing where the money had gone. I did not expect to need those skills for my own grandmother's estate. I did not expect my parents to be the case I was working, but the work is the same regardless of who it involves. You pull the records, you follow the numbers, you build the spreadsheet one row at a time until the picture is complete. And when it is complete, you present it clearly, without embellishment, and you let it say what it says. The numbers said she meant for me to have something. They were right. They are always right. The money is in the account. It is mine, Prost. And somewhere in the documentation that produced it is the last clear record of my grandmother's intention, the trust she wrote 12 years before she died, with my name in it, Frang. Trying to take care of me across whatever distance would eventually separate us. She did. It just took a spreadsheet to prove it. If you believe family lies always leave records behind, subscribe before the next folder is opened. They said she left me nothing. They forgot she so raised the person who would audit the account.